Okay, we'll go ahead and get started. Welcome, everyone. Good afternoon. And we'd love to welcome you to the first ever Lathrop GPM Virtual State of Litigation. I did not say first annual because we're hoping at some point we can all be in person again one day. I'm Mara Kohara and I lead the Environmental Tort Group at Lathrop GPM. I'm a litigator and a member of the firm's executive committee. I've been with Lathrop for almost 20 years. And I am currently presenting to you from my home office / son's bedroom. It's the best I could do to get away from the noise. For those of you that have attended the in-person Kansas City event in the past, this year marks our 15th annual State of Litigation Conference. It has grown significantly over the past 14 years, and we are thrilled to see it grow even more since we're able to present across all of our offices and throughout the country with each of you today. This event was originally created to present strategies on how to manage litigation more effectively, discuss trends shaping litigation, and also provide a forum for networking. As many of you know, Lathrop GPM is a product of a merger that occurred in January of this year. Lathrop Gage merged with Gray Plant Moody, and the combination has created a stronger law firm with almost 400 attorneys in 14 offices around the country. So now on today's agenda. First, you're going to hear from myself and three of my colleagues, Brian Dillon, Matt Jacober, and Jennifer Hanna, on the current state of litigation, which obviously is a bit different, and thought that would be a timely topic for today. Following that presentation, we're excited to have Rithu Bhasin join us for a diversity presentation focusing on cultural competence and how to be aware of our cultural differences and how they can shape our interactions. But before we dive in, we've got a few housekeeping items. First, we have applied for CLE in California, Colorado, Illinois, Kansas, Minnesota, Missouri, and Texas. When CLE has been approved in each state, we will distribute that information with any relevant certificates of attendance. Those of you seeking CLE credit in Kansas will need to take note of the code up on the PowerPoint slide right now. Kansas does ask that you verify that code. So if you indicated upon registration that you're seeking CLE credit in Kansas, we will be reaching out to you in the next few days. We welcome your questions and comments during this presentation. I will say not the text of my colleagues that are commenting on my blazer and that I need to smile, but you're welcome to make questions for us. We have a chat feature and we will do our best to get those answered or incorporated them into our presentation as we go. If we can't get to your question, we'll be more than happy to follow up with you after the event. And I think you can see in each of the presenters' boxes, we have our email addresses. And we'll also be taking note from the chat feature afterwards. Finally, the state of litigation, this portion, today's will be posted on our website within 24 hours. You'll all receive a link to the recording and we encourage you to share it with others in your organization. Now, Rithu's presentation will not be recorded, so that will not be something that you can share. And with that, I, without further ado, want to welcome my co-presenters and we'll do some quick introductions. I'll start with Jennifer Hanna. But first, that's me. We have some neat backgrounds. But now for Jennifer Hanna.
Good afternoon. Obviously, we are in a different environment presenting this way. As Mara said, I have been with Lathrop now for 20 years. I've been practicing for over 20, but obviously with Lathrop for the majority of that time. I currently lead our accounting, liability, and risk management team for the firm and also specialize in fiduciary, shareholder litigation, other commercial litigation, and restrictive covenant and trade secret litigation. And if we didn't have enough, we had pandemic occur and we all went to our home offices in March of this year, or our bedroom, like Matt Jacober, / office. Luckily, we at least had a crystal ball in mind 2 years ago, and we remodeled our home office and have 2 workstations. And so I never thought my husband, who's a non-lawyer, and I would be working side by side one another. Also, that crystal ball didn't work very well though, because pre-pandemic, we decided to build a new house and then put our house on the market as well. So that's why you see virtual litigation, building and selling a house. And I have a sixth grade boy and a sophomore daughter. So keeping them to social distance and stay out of our hairs has been interesting. And at least we are still married. We will have our 21st anniversary tomorrow. And I don't need to be talking to divorce lawyers yet. So with that, we will move on to our next presenter as well.
That would be me. Good afternoon, everyone. My name is Brian Dillon. I'm a trial lawyer based in Lathrop GPM's Minneapolis office. I am actually in our office here in Minneapolis for the first time in 4 months. It's very strange. Happy to report that my one office plant is still surviving. I didn't trust my children or my home internet connection to cooperate today, so I decided to come in. I've been doing this work for about 20 years. I specialize in trust and estates disputes, shareholder and fiduciary litigation, and defending clients facing administrative and regulatory enforcement action at the federal, state, and local level. My spouse is also a busy lawyer. She's got a transactional practice. She doesn't practice in the dark arts of litigation like we do. We also, as I mentioned, we have got a couple of kids at home, all under the age of 8. So like many, I'm sure, who are listening into this discussion, whatever lines there used to be between the work life and the home life pre-COVID, they've been completely obliterated, but we're managing. So welcome, everyone.
And not last but not least, Matt Jacober.
Thanks, Maura. Thanks, Brian and Jennifer. Hi, everybody. Matt Jacober. I'm a partner at Lathrop GPM in the St. Louis office, and I am the practice group leader for the Litigation and Dispute Resolution Practice Group. We have lawyers in that group in almost all of the offices that we have across the country, and we are the general litigators in the firm. We specialize in everything and nothing all at the same time. Which reflects my practice as well. Being in a smaller office like St. Louis, where there's still a lot of clients and needs, my practice touches numerous different areas, including trust and estate disputes, business divorces, shareholder disputes, tort environmental matters, contract disputes, and I also, like Brian, do some governmental investigation work. We can all talk about how our lives have changed so dramatically since we went to a shelter in place and then transitioned into a work from home and don't have a clear guide when any of that is going to end for good, and we're going to get back to what life was like before, or at least some semblance of what that was before. But, as litigators, I like the dark art of litigation, as Brian said. As litigators, our favorite place to be is the courthouse, and that's been tough managing, keeping cases going forward, and adjusting expectations of clients since courthouse is shut down. I've been able to get back into them recently, especially in more out counties in Missouri, and that's been a welcome return to something like normal, although it is a little more difficult making an argument with a mask over your face. But we look forward to talking to you today and trying to answer your questions or just addressing things from our perspective. Thank you.
Thank you, Matt. I'm trying to picture a mask over your beard. We're going to start our presentation today. And in my notes, it actually says, the pandemic happened, what changed, and what has worked well and what hasn't. Obviously, the pandemic it's happening. It's not happened. We're in the midst of it. So I'm going to start and first go to Jennifer Hanna and see if she could comment on what are the biggest changes that you're seeing in litigation.
Yeah, thanks, Mara. I know we're going to talk about some specifics later, but I want to talk about kind of general big picture of what we saw. As we know from when I started practicing over 20 years ago, I mean, today things are, more electronic than ever. I mean, we file our pleadings electronically. So much occurs via email or virtually or by phone. So what was the biggest thing that really changed for us when pandemic hit, and it's still continuing? I'd have to say the biggest things were the closure of the courts to the public, and also moving a lot of things that we would normally do in person, court hearings or depositions, moving that all virtual. So those were probably some of the biggest things that we saw change. But one other big change that happened, which was really to our clients, is navigating litigation in this space, and specifically discovery. Our clients were affected by this, and trying to gather documents in discovery and meet with people and witnesses when businesses had shutdowns, furloughs, and everybody was working from home. That was a huge change. And so while most people were able to kind of get back up and running right away, as far as keeping the train moving down the road in litigation, I would say the court closure to public space, and also where our clients are, but also helping get a bunch of people to navigate technology. It's interesting how we now hear people who never thought they would be able to work from home or do things virtually suddenly say, I really like this method now. So I think overall, those are kind of the big things that we saw strained, and pun intended, the jury is probably still out as to how some of these will affect us in the future.
Mara, you're muted.
The mute button is what's changed the most for me. Next, Brian, we'd love to hear from you.
Yeah, well, I mean, we're in a whole new world, no surprise, right? And, the legal system continues to chug along. We're all adjusting on the fly, relying more heavily on, new tools and modes of communication. And, I think the biggest change for me, is you used to be able to depend on your scheduling order and kind of have some sense of how the life cycle of a case was going to play out. Now I think it's just you got to be flexible and expect the unexpected, right? And have the ability to adjust depending on circumstances, right? I mean, like the general population, the stakeholders in the legal system have different sensitivities to COVID, right? And it varies from case to case, judge to judge, court to court, depends on the venue you're in, the experiences of your stakeholders with COVID and amongst their colleagues and family members. As Jennifer said, if you want a jury trial, right, I mean, prepare to wait in a civil case. We're slowly starting to see jury trials come back, at least in the Minneapolis market, in some criminal cases, but TBD on when that's going to happen in civil cases. But I think by and large, judges are becoming much more comfortable with the technology and Zoom and other sort of virtual technology as an alternative. All of my trials and evidentiary hearings from mid-March till now and into kind of late summer, early fall have been converted to virtual with really no real problem. So, I guess, my biggest takeaway is just prepare everyone on your team to be flexible and adjust on the fly and be as comfortable as possible with the technology.
Great, thank you. Now, Matt, you may unmute.
Thank you. Yeah, I'm not going to spend a lot of time adding to what Jennifer and Brian have already shared, because I think we're all seeing very similar things in the changes of the environment in litigation. The big thing that I've taken away from this is lawyers, I think we think of ourselves as people who aren't particularly adaptable. at least not very quickly. We like the status quo. We like things being the way they were last month. But if this has taught me anything, we're more adaptable as a group of people than I really thought we were. And in particular, in how we go about being persuasive to courts and how we go about getting evidence from people, in particular in depositions, which I know we're going to talk on a little bit later in more detail. But what has impressed me more than anything, or impressed upon me more than anything, is at the very beginning of this, there was a very quick shift of most people in their level of cooperation, as Brian said, in adjusting scheduling orders and trying to work with one another on discovery issues. And once we all got used to this format and this venue, that we went back to where we were before. And we're having battles over discovery issues, and people are willing to say, no, you can't just have an indeterminate amount of time to get documents together because it just doesn't ring true anymore. So that's been kind of an evolution of where things have gone from what I've seen. And I did want to add, totally off topic, but I know a lot of people have been asking on the chat what the Kansas CLE code is, and that went off the slide. That code is LGPM0716.
Thanks for that, Matt. Now we're going to sort of talk and give you our thoughts on what does the litigation landscape look like now, and how are we, reacting to it. I'll just start quickly with one thing I've noticed is in how looking and seeing the rule courts actually learning to adapt to technology. Many of them didn't have the ability before. You couldn't have a phone conference, if you will, even in chambers. And now they're having to figure out how to, the judges at home. But I think I've noticed a lot of the rule judges realizing that they can do this more virtually and perhaps allow folks to do by phone or video in the future when we do go back into an actual courthouse setting. But then we'll hear from Matt again. I gave my answer just so you had just a 1-minute break from Matt before he responded.
Thanks, Maura. And a question came up. Somebody asked me to repeat the code, so I'll do it one more time, and I'll pause a little bit so everybody can get a pen and paper in front of them. It is LGPM0716. That's the Kansas CLE code. So, the landscape now, it appears that we're going to, at least to some extent, we're going to be in this format, in this new world for some period of time. As the economy began to open, cases started to go up, and courts have shown willingness to allow hearings again in person, but in a different way. And every judge I've been in front of has commented and lamented that they are horribly behind on criminal matters. And of course, the Speedy Trial Act gives criminal defendants the ability to push those cases forward. And the judges are very concerned that they are going to have to push civil cases to the back burner, in particular civil jury trials to the back burner for some period of time. I think if you're willing to do a bench trial, you can probably fit that in. It may be broken up over several weeks where you get afternoons or mornings when criminal matters aren't in front of the court. But most courts are going to have to commit their resources to criminal trials. And I think that's what the litigation landscape is going to look, how it's going to look differently going forward. And how we react to it is going to be really up to the parties. Are you willing to sacrifice a jury trial? Are you willing to explore alternative dispute resolution? Maybe you don't have an arbitration provision in your contract, or it's not a contractual matter, but you decide in the interest of getting this finished, you're going to go to arbitration, and you're going to pay AAA or JAMS to arbitrate your matters for you. And I think that's going to be very much up to the parties. But in the short term, there is going to be a slowdown in civil litigation working its way through the courthouse, in my opinion.
Thank you, Matt. Brian, what are your thoughts?
Yeah, I mean, dovetailing on what Matt said, I mean, and as I mentioned before, if you want a civil jury trial, prepare to wait. I was talking to my father last night. He's been a judge in Wisconsin for 20 years or so. And he's a 75-year-old guy who, is not super technologically savvy, but I was telling him about, what we were going to be talking about today. And he was saying, I actually think Zoom works really well. As long as I can see someone's face, I can make credibility determinations, through Zoom just as well as I can in person. And I think he's been surprised by that. And, other folks who I've talked to have been, sort of using Zoom now for a while have said the same thing. The one thing that I have found that's been kind of interesting is that, now that we are virtual, I feel like, stakeholders in a particular case are showing up to proceedings maybe more often than they would have had they had to, get in their vehicle and find their way to the courthouse, right? So you've got more people zooming in to a proceeding, and you've got more faces in the squares, and it can be a little, it becomes more difficult, I think, for the moderator of whatever proceeding it is, whether it's a mediator, an arbitrator, or a judge to manage. I've seen some judges kind of proactively use the mute button to tell people it's done for you to be talking now, right? I mean, but it is everybody's got the same size square, whether they're a client or a witness or a lawyer. And so that's been really interesting. But in some ways, I think there's a real benefit, right? I mean, this has been a disruption, and disruption causes us to sort of think about what we do in different ways. And in some ways, like the legal system is becoming more accessible to people, because all they have to do is, click a button on their computer and all of a sudden they're in the room. So in that way, I think, if this does increase accessibility, I think about my trust and estates litigation practice, right? Where, many of my clients can be a little bit older, right? And it's harder for them to travel into downtown Minneapolis if that's where we are, or, in some cases to leave their nursing home, right? If they're prohibited from leaving their nursing home because of COVID, which many have in the last couple of months, at least in some of my matters, they can still be there. And so in that way, there are some challenges when there are more people present, but accessibility, I think in general is a good thing. So we're, I think still navigating through what I think is probably the beginning of a new normal, and what sticks on the other side of this. Like, what does the litigation practice look like when we're hopefully beyond COVID-19? Who knows? It'll be really interesting to see. But I do think the new world will be much more virtual and kind of over the computer than it was before.
Jennifer, what are your thoughts?
Yeah, and to tie in on what Brian just said, I think we're seeing a lot, obviously, since things are going virtually, there are some good things that will come from this, and we'll talk about a lot of that later. But I do, depositions, whereas the majority of the time those were done in person, in a conference room, paper being exchanged among one another constantly. Now you're seeing a variety of different services that are out there to be able to do depositions virtually. It is saving clients time and money, where we would be getting on an airplane and going for a deposition, or getting in the car and driving somewhere. And all of that time, there's a lot of efficiency that's being saved. You're better prepared going in because you have your exhibits, they're all ready. you've had them marked, and as long as you can work the technology, which I can say is usually pretty user-friendly, I think it's helping our clients, and they can participate from their chairs and from their homes as well. We have done some depositions in person as well. Matt was talking about court proceedings in person. I think the big change that we're going to see is, do you opt for, so if you're in person and you've got a mask on while testifying, does that help you test that person's credibility? So much of what we do is based upon, if it's in person, reading the body cues of the person who's testifying. How is that person going to make as a witness? Well, when you're deposing that person in a situation that is already stressed and they've got a face mask on, is that really how they're going to appear at trial? And so, opting, what are you going to opt for? Are you going to opt for the virtual deposition? Are you going to opt for the deposition in person? Some of the individual experiences we'll talk about, but it may be on a case-by-case basis. I will say I got an email fortuitously timing, but last night the Johnson County District Court in Kansas actually sent out an email asking people to opt in, if you will, to try virtual trials. I know we've heard about some virtual trials that have started to go on in some other jurisdictions, but allowing for people to opt into this virtual jury trial, not only for jury selection, but also potentially for witnesses, and they would then allow that to be a non-binding verdict and then go on to mediation. So, the one thing I do think, we're doing is we're adapting to the change. Both businesses and the lawyers and the courts are adapting. One thing that judges used to always tell me, they didn't like how proceedings were becoming via email, and they liked still getting lawyers in the courtroom, because one of the things that both Brian and Matt touched on is the civility among lawyers, and one way or the other. We talked about when pandemic hit, people were becoming more agreeable about moving deadlines and having this grace and humility to work with one another. And so judges have always said that they like having people in person because it's much more difficult, not impossible, but much more difficult to be that jerk to somebody in person or in front of the judge. Now with Zoom and other mediums out there, I think courts feel now comfortable with having people in person, or instead of having them in person, having them virtually, and it still gives that same, camaraderie and civility among the bar with everyone. So, I think we'll see more and more, even when, hopefully very soon, when we're past this, that courts and our clients will start to demand some more efficiency, going to virtual depositions and doing Zoom hearings. So.
Thank you. Now we're just going to probably share with you our individual experiences since the COVID and how we've been practicing virtually by and large. And we'll start with Brian.
Sure. So a couple of anecdotes I'll share, both of which sort of evidence the need, I think, to prepare clients and team members on the technology that's being used and proper decorum for, trying cases or appearing in front of a court in a virtual setting. I think everybody read a couple of weeks and maybe even a month ago now, all the days seem to blur together, but there was the US Supreme Court argument where you could hear a toilet flushing in the background, right? I mean, put your mute button on, right? First and foremost. And, if you're not speaking, but your picture is up on the screen, that can be distracting, right? So I've told my clients, like, if we just got a motion hearing and you want to listen in, as somebody mentioned earlier, like, it's a lot easier sometimes for a client, especially an in-house lawyer, or, a busy professional, rather than get a download from me on what happened in a particular hearing. It's pretty easy to click a button and you can sit through that half hour or hour and hear it for yourself, right? So you've got more participants. But if you're not speaking or sort of actively engaging with whoever the facilitator is, right? I mean, taking your video off is I think wise counsel. And the other thing I would say too is that, you know, when you're in a courtroom, the solemnity of the proceeding is obvious. When you're in your living room, it's a little less obvious, right? And you know, I had a telephonic hearing not long ago where, you know, we were, you know, arguing, you know, several different parties arguing before a judge. And, you know, opposing counsel at the beginning, you know, indicated that he was in his office and that, you know, he and his client and colleagues were practicing social distancing. His client was in a neighboring conference room, but, you know, he went ahead and gave his presentation. And it was fairly contentious on a couple of different issues, as this particular case has been over the course of the last several years. And his client is, you know, has been an interesting and difficult personality at different points in time. And we got off, the telephone conference was over, but we were still on the line, right? And I was still on the line, and I'm confident that court staff was still on the line, but the judge has said, okay, you know, we're done, thank you very much. Whether the judge was still on the line, I'm not sure. But before opposing counsel hung up his line, we could hear him like light up his client and his co-counsel for essentially distracting him during this telephonic hearing, and use some fairly choice language. And we, you know, myself, then I got off and, you know, called my own client. I was like, did you guys hear that? Like, you think the judge heard that? It was not a good look, right? So nobody wants that to happen. And, you know, you really, as I kind of said, you got to understand the technology. You have to appreciate that although we are in a different environment, these are still judicial proceedings, especially when you're in front of a judge. You need to give it you know, treat it as importantly as it needs to be treated, as if you were in a courtroom. And if you fail to do that, it can really be, you know, a bad look for you and your client.
Thank you, Brian. I'm dying to hear what he said, but I know you probably can't repeat it.
This is at least PG or PG-13.
Yeah.
I'm not gonna go there.
And now we'll go to Matt, because I know, Matt, you just recently had a virtual arbitration, and I think that'll be helpful for us to hear about that.
I did. We had a virtual arbitration that two associates and I tried in the middle of June over 3 days, and it was expedited under the AAA rules. So limited discovery, but some discovery, limited pretrial briefing. We had a really good arbitrator who spent a lot of time working to be prepared on the facts and the law. And don't have a decision yet. So if an arbitrator's on, that is pure pandering right there. But some of what Brian just talked about were lessons that we also learned. In particular, I want to zero on the communication between your team and your client, because one of the things that we were very concerned about was what happened on breaks. And making sure that on breaks we got into a room that was private so we could have a conversation with our client, and that everyone didn't lose their Zoom connection and didn't have to reconnect and worry about technology working again. AAA did a great job at having a separate room for everyone where you could go in and out of your own accord. But my team, the lawyers from Lathrop who tried the case with me, we, besides having Zoom and our email, we also use Microsoft Teams. And we decided early on that we're going to have a separate Teams chat going during the questioning, which was actually turned out to be an incredibly great thing, because we were all able to provide context and help on questioning, because you know when you start to get into questioning, sometimes you start to get a little bit of tunnel vision, and you fail to look at some of the outside stuff. And it was very helpful to have real time, but not somebody slide in a piece of paper across the table where it's so apparent what's happening. Real time, where it's off to the side, you can look at it when you see it flash in your peripheral, and you can incorporate that into your questioning as it's happening. But the number one biggest lesson that we learned was whatever you think your preparation needs to be for a trial or for a deposition or for really anything, for anything that's virtual, you need to double that level of preparation. Everybody has to be on the same page. You have to have everything marked. You have to have everything absolutely ready to go, which was, I think, to Jennifer's point on the deposition, where you really are more prepared when you go in. That was abundantly true in our arbitration, and in my opinion, that was a good component, a good thing that we did, that the other side didn't show that same level of preparation, which allowed us to present a more polished and relaxed presentation style to the arbitrator, which our clients commented on after the arbitration.
Thanks, Matt. Jennifer, do you have an individual experience or experiences you want to share?
Yes, as I mentioned, so I've done the court hearings and everything via virtual now. I've done depositions virtual and in person. And I want to kind of talk about that because, you know, I'm somebody who, it's hard for me even to argue in front of a court sitting from a chair. I'm used to being able to stand up and present to a court, and you feel like you're slouching down and not giving the respect. But and I like the deposition. I like being in person for a deposition, but I also understand the constraints. I had a case that was a very document intensive. It was an accounting liability case, and we were trying to decide whether we were going to do that in person and or virtually. We decided to do it in person, and this was right after quarantine, but making sure that we had every exhibit marked in advance in a notebook separately, that wasn't being touched by anyone during the deposition, you know, rooms socially distant apart from everyone in the conference room, etc. That was an option, and luckily it was local, and so we did that. But I've also had depositions now in which we have a case in Ohio that's going to trial, cross our fingers, in September, and all of those have been virtual. We've got people from all different jurisdictions coming in virtually, and so far it has been pretty smooth. I do note, I talked with our IT right before this, some softwares, you know, technology is as good as it is. It's great, but at one point in time, the court reporter had accidentally kicked off a couple of us from the phone line. And so we were there. It looked like we were still virtual and in the deposition, but our phone line was cut off. So we called back in, and we had to sit in a waiting room until the court reporter saw the chat feature up and everybody saying, you know, we need to get back into the deposition. So it happens. Again, like I said, grace and humility, everybody's going through this. And so trying to get through that. I have the first jury trial that's set in October. October 5th, I believe, is the first day that Jackson County will have jury trials going. I'm set to have a jury trial then. We'll see if they actually go. As of right now, everybody will be in masks. So I'm not certain how that will work well for purposes of witnesses, jurors, etc. I know somebody asked a question in the chat as well about the Johnson County. I don't have a lot of details on it. What I do know is that what they're saying is that they would get people immediately into mediation, probably court-ordered mediation following this non-binding jury trial. The alternative is, if you don't do that, you may not have a trial until 2022. I can tell you that I just had a case that we were setting for trial, and the first civil jury trial setting we could get was in March of 2022. So, you know, somebody had asked a question in the chat as well about, you know, what are we seeing, you know, are companies doing things to get them sued, and what can they do? I just want to say, from an individual experience point as well, what we're seeing is there's going to be a rise of litigation. In 2008, when the economy took a downturn, you saw a rise in litigation. You're going to see that now as well, and we're seeing that. We're seeing clients that are that don't normally see a huge uptick in litigation are seeing some. When people are pressured, when the economy is pressured, you see that go. And so we'll talk about in a little bit some tips and things that companies might want to decide. But if you have the choice of not getting your trial until 2022 or 2023, you may opt for a different method. So that's kind of some individual experiences, and I know we'll next talk about some tips and best practices.
Yes, after I share a couple of my experiences, and I've had a couple of mediations, and I will say you really want to, when selecting your mediator, make sure you have a mediator that has done a virtual mediation. I had one in New Mexico a couple weeks ago, and he was phenomenal. He was a retired judge, and he knew how to use the Zoom rooms, could go back and forth very quickly. And you know, when it was time for him to come back after he talked to us, all we had to do was text his number and say ready. And, you know, of course, I look at my text to this mediator and I had 20 readies by the end, but it really went off without a hitch. And we had 5 people on our side in our Zoom room. And then, you know, they had other on the other side. And other than opening up altogether, we never had any issue or thought that we might be able to hear one another. And even if someone came off, for instance, my client had to go for a bit, he was worried when he called back in that he would just be put into the general room. But our mediator knew enough to who it was and to make sure to set them into the correct room. So I thought that was a really great process. And I could see mediations like that happening even after things go back to more of an in-person normal. On depositions, I think the neat thing for me in the depositions I've had recently, clients that have, you know, in-house clients that also have interns, it's been a great opportunity for their interns to see depositions. I mean, obviously it's different than what, you know, they would see if they were in person, but it's allowed, you know, the clients and interns and the paralegals for clients all to join and kind of participate in the depositions. And I think Brian had sort of just talked about that. It doesn't seem like a crowded room then. If we're all in person, if all those folks showed up, it'd be one thing. I mean, certainly we got the permission from the other side to make sure that that was okay before it happened. And by and large, the clients and the interns did not have their video going. They just had, you know, their name or a blank screen, but we knew who was going to be on it. And I think it was, you know, a great experience for our clients. And, you know, we did make sure that paper exhibits were sent and organized beforehand. And we've now had 3 days. The one issue we did have, and it is technology can be, you know, kind of, you know, really, really good one day. And then we had the follow-up deposition of the same witness, and he just could not get his internet to work the next day. So grace is definitely something that is helpful. And it was an attorney I'd worked with before. And so he was gracious enough to let us reschedule and work on our witnesses' internet availability for the client. And that happened yesterday without a hitch, maybe 1 or 2 glitches, but that was all. So my experiences really have been great, and I didn't have to drive to Cedar Rapids from Kansas City, which isn't the most exciting drive, and I'm sure the client was happy not to pay for that. But those are kind of sort of my individual experience of late. It's always great to be in person with your clients and witnesses, but this really is becoming, as we do more of them, more comfortable. And the other thing we did, we had, like you did, Matt, and talked about having the separate Teams meeting. We had a separate Zoom meeting, and everyone got really good when they knew you were shutting off the deposition, went right into the Zoom meeting to download before we took our individual breaks, you know, to get food. So that was a great thing too. Kind of what we've been talking about, I think also talks about practical tips and best practices, but that's sort of our next topic. And I'll just say, I failed in the first practical tip. I told my family, no one come in here, keep the dog downstairs. I have a very important state of litigation. And 2 seconds before we went live, my son threw the dog into the office. So thankfully he is still sleeping, but my practical tip was, make sure your family, your kids, your pets, perhaps people working at your home all know not to come into where your office is if you don't want to be interrupted. So signs are probably helpful, but that's just a practical tip working from home, and obviously it does not always work. But Jennifer, what are your practical tips and best practices?
I have to laugh because Mara and I share a lot of similar experiences, and I wanted to say I knew she was going to talk about that, and ditto on that. And similarly, right before I had texted my kids, told my husband, everybody, you know, out of here for an hour, let me talk. And then right before we went live on here, our golden doodle parked himself right behind my chair here and is asleep. And so I'm hoping to gosh that the Amazon person doesn't come and deliver something to my doorstep and he start barking here in a little bit. But yes, you know your environment. Also, when you're talking to clients, understand that, you know, understand their environment, and you know, they may not have the same flexibility that you do. So sometimes you have to be a little bit more flexible on your time. So a client may be working from home still, and that client representative may have really young kids. And so it may be easier for them to talk early in the morning or later in the evening. And so try to be flexible in those situations. Remember, if you have your video on and you think that you have turned, you know, make sure that you double check to turn off your video and your mute. I had an interesting experience, and I guess I'll, from a humility standpoint, share it so people learn. But I was on an internal just team call, and I thought, okay, I shut off my video. I thought I had shut off my mic, and I walked out of the office to check on what the dog was doing, and I immediately explained, stop licking the carpet. Then I suddenly heard, hey, Jennifer, you're not on mute, but who's licking the carpet? So my partners all got a good laugh. I had to laugh about it because, again, I mean, in this situation, at some point in time, we do have to laugh about this and have some bit of humor in it as well. Not everything is going to be perfect, but think about if you are going to be presenting to a court, if you're going to be presenting to a client, again, make certain that, you know, you don't have a ton of stuff going on in the background as well. But those are kind of some of my practical tips. It's not always going to work, but I think, Brian, give some more.
Yeah, I mean, I think we've all kind of become like evening TV producers, and in addition to being lawyers, right? I mean, you're trying to figure out how do I present best on a, you know, 2x2 screen, right? And so it's, you know, getting rid of the clutter in the background and staring into the camera and you know, avoiding tics, right? Facial tics and what have you. And that's new and different. You know, you don't want to be the party that's fumbling the technology, right? In addition to, you don't want that to take away from the message you're trying to deliver in whatever setting. So, you know, learning the technology engaging technology consultants when necessary. I mean, I know we've talked to a few in connection with our work that they can do some things that are kind of magical, you know, and we know the basics of Zoom. We know how to introduce documents and in depositions and in court proceedings, but they really know. I mean, you know, we've got paralegals and other lit support staff who know how to make us look good in the courtroom, but they're still learning as we're still learning about how to do it virtually. And that's a new skill set that I think we'll continue to learn over time. But it's, you know, it's a bit of a fire hose still, I think, for many. And having the flexibility and the adaptability and the humility, as Jennifer said, you're not going to get it perfect all the time, but you want to get it as perfect as possible, as much of the time as possible. And so spending the extra time to prepare, not just on the substance, but on the process, is really key. The other thing, you know, one of the other things I'll say too is that, you know, there is a backlog. We all know there's a backlog. Getting the court's attention is harder than ever. One of the things I'm seeing is, you know, trying to figure out ways to get the court's attention and fashion sort of whatever you're asking for as an emergency kind of a situation, right? So, you know, I'm seeing more motions for temporary restraining orders, temporary injunctions, really maybe in situations where you might not have seen it pre-COVID, just as a way to kind of jump the queue and get in front of it, which has been kind of an interesting development. And then just one other thing I'll say in response to one of the questions on the chat right now is voir dire. How is that happening? I can just tell you in my experience here locally, there are 4 courtrooms set up in the Hennepin County Government Center for criminal trials. And, you know, for the jury portion of after the jury is selected, those are happening in the courtroom. Social distancing is happening. Jurors are separated. But for voir dire, there's just not enough room in these 4 courtrooms that can accommodate a trial to do the voir dire portion. There's just too many people. You can't do it. So jurors are being called in, but the courts are setting up ante rooms so that, you know, people are sort of piped in through the television. They're in the courtroom. They're just in an adjoining room where they can spread out. So it's happening. It's sort of, you know, again, we're adjusting, trying to deal with the backlog as best we can, but everything is kind of new and different.
How about you, Matt? Any kind of final thoughts on?
Yeah, not much to add to what everyone has said. My only addition would be, if you're going to, you know, we went virtual and we became at least close to experts on what Zoom or whatever platform you happen to be working with as quickly as could be expected. And this is in particular true in the trust and estates arena that Brian and I both litigate and Jennifer litigates in, and some of the shareholder dispute cases where those people might not be in an environment, those clients may not be in an environment where they're relying on Zoom or WebEx or whatever the technology is to communicate. But because you need to move the case forward, they're going to have to do that. So the thing that kind of the practical tip that I learned was it's very important with people who aren't comfortable with Zoom to practice and practice a lot, because if they're going to testify at a deposition or at an arbitration trial, they're already going to have that heightened level of anxiety. Don't dump on top of them the additional anxiety of having to manage technology that they're not comfortable with. So take that out of the equation. And I just saw a question that popped up in relation to force majeure contract clauses. When the pandemic started, we began a COVID-19 client response team. And all of those materials are on our website. They're accessible. I've been leading that effort for the firm. And we have a couple people, myself included, who have focused a lot on force majeure contract clauses, both from parties who are trying to enforce contracts with force majeure clause in them, and from clients who are trying to get out of contracts. The most frequent place that we've seen it happen has been in hotel accommodations, conventions, large meetings, blocks of rooms, things of that nature for weddings. It's been kind of run the gamut. Right now, we haven't had any cases go into litigation yet. The parties have been able to reach resolutions. You know, with a wedding, you rebook and there's maybe a penalty paid and some credit later. With contracts or conventions, same thing. But what I have seen happen over the last, at the beginning of this, you know, there's been this kind of trend where people were more agreeable at the beginning of this, and then everyone's kind of reverting back to business as usual. The humility and grace that Jennifer has talked about is starting to trail off a little bit, from my experience. So it looks like we're dealing with a couple of those right now where it looks like they're going to head into litigation. And as somebody who did the research early on, there's not a lot of cases out there on force majeure anywhere because it usually doesn't apply. It's one of those clauses that drafters put in contracts because we were all taught to include that as a potential out on a contract. So that's going to be interesting. It's going to be a body of law that develops quickly, I believe, because I think those clauses and those issues in contracts are going to become prevalent over the next couple of years. That's all I have.
No, thank you, Matt. And your comment regarding our website and when you can get COVID-19 information to the gentleman that asked about the trends and if we're seeing things that companies are facing, we try to stay very much on top of that. And so that is a great resource to see, you know, things that are happening. So thank you for that reminder, Matt. Thank you, everyone. I know we're reaching the end, and for those that are asking about codes or getting registered, we will certainly reach out to you and make sure that you get that information. We hope you enjoyed some of our war stories about what litigation is starting to look like and may look like in the future. And we appreciate your time and hope you'll join us for the rest of the afternoon when we hear from Ritu, and then also our next two sessions that'll happen the next 2 Thursdays. But first, I just want to say thank you to Jennifer, Brian, and Matt. Always a pleasure to present with you, and appreciate everyone's time today. If you have any other further questions for any of us, please do not hesitate to reach out. Thank you very much. We'll end this session, and then we will move over into the next. And so I'm reminded to tell our current presenters to please close your video and make sure you're on mute.
Thanks.
Thank you all.
Thanks, everyone.
Thanks, everyone.